Good afternoon, everyone, and welcome to our Distinguished Visitor Lecture Series. I'm Deborah Parks, and I'm on faculty here, and one of the roles I have is as chair of our Distinguished Visitor Committee. So one of the events we're putting on this year for the first time is Wrongful Conviction Day. And many of you may know about the reality of wrongful convictions in Canada and, in fact, you know, in all the justice systems around the world. And an organization called Association in Defense of the Wrongfully Convicted here in Canada has been spearheading the initiative to have Wrongful Conviction Day declared, and so it's going to be from now on October 2nd, and this is the first of the Wrongful Conviction Day. As members of the legal profession in the future, and I would say already as law students, you are members of the legal community, and it's important for us to all think about the responsibility we play and the roles that we have in trying to bring justice and trying to actually do justice, but also being aware of when we do injustice. And I think that it's very important that we reflect on that and that we have opportunities to be aware of where we have gone horribly wrong, where we continue to be going wrong, and what we can actually do about it. And so it is my great pleasure to introduce you to the speaker we have today. I couldn't think of anyone better, and I was so delighted that she accepted our invitation to come to give this inaugural lecture on Wrongful Conviction Day here at Robson Hall. We have with us Kim Pate, who is the currently this year the Ariel Sallows Chair in Human Rights at the University of Saskatchewan College of Law. She is also at the same time still doing her other full-time job, which is as Executive Director of the Canadian Association of Elizabeth Fry Societies, which is an organization that advocates for criminalized women and girls and advocates for their rights and for it takes a critical view of our society's use of imprisonment in relation to women, but in fact more broadly. And Kim I got to know Kim when I was a law student at UBC, when I was writing a paper for a class I was taking on penal policy with Professor Michael Jackson at UBC, and I wanted to write on some of the issues around women in prison in Canada. And at the time, I learned that there were women being incarcerated in segregated units inside men's maximum security prisons. This was one of the responses to a lot of advocacy that had been done to try to close down the prison for women in Kingston, which had been the subject of many reports, commissions of inquiry, and recognition of many problems and abuses there, and to build regional prisons that would be more responsive to women. What I think Kim has found in her work, and what I found very soon when I actually interviewed her for my research project as a law student, was that some of the best intentions around reform can lead to more problems and injustice, and this legacy we see that with women's imprisonment in Canada, and many of you know that's an area that I'm quite interested in, I research in, but Kim has been my teacher on that, and I have learned so much. Every time I hear Kim speak, and we've co-written articles together, we talk a lot, and every single time I hear her speak, I learn something new. So I'm looking forward to what I'm going to learn new today, and I hope that you will have an opportunity to learn from Kim today, because she is really a leading advocate for human rights in Canada, and we're very lucky to have her here.
Well, thank you for that very generous introduction, Deborah. I learn from you, and in fact, you do mostly all the writing. I just get to tag my name on usually. So I'm very, very pleased to be here. I'm, in fact, honored and humbled to be here. And I want to start, as I always do, by acknowledging the traditional territory on which we have the privilege of meeting, Treaty 1 territory. And as most of you, I hope, will already know, this is Anishinaabe, the territory of Anishinaabe peoples and the homeland of the Métis Nation. And very close to here, in fact, the Forks, which is we're in relative proximity to on the university campus here, is the crossroads for the Anishinaabe, the Cree, the Dakota, and the Oji-Cree nations. And why is it very important? Not just for the obvious reasons of why it's important to acknowledge traditional territory, but in the last 30 years that I've had the privilege and responsibility of walking in, but most importantly being able to walk out of prisons for young people, for men, and for women, it's painfully obvious the impact of colonization, particularly in this province and in the province that I'm now resident for this year. And so it's vital that we talk about that. And I will talk a bit about that in this. And I want to thank Deborah for all the work she's done for decades and the teaching she does, both here, her involvement with our organization for many years, her leadership on many issues of human rights abuses here in this province and nationally and internationally. And on this particular issue, the incredible work and writing that you've done, Deborah, on wrongful convictions and that you've done with Emma Cunliffe out of the UBC. I think those are incredible contributions, and really you could be standing here doing this lecture. So if you want to read more about some of the theoretical and criminal law components of what I'm going to speak about, read the article that Deborah and Emma have just written. I'll send it to you if Deborah's too shy to. I hope she's not. But I want to talk to you about a few themes that I have observed, particularly in the last 23 years since I've been working more predominantly with women and girls, but that I also saw when I worked with young people and with men. And the fact that I've been invited here on the inaugural celebration, if I can put it, or recognition, or observance, perhaps is probably the best way to term it, of Wrongful Conviction Day. I think it's really appropriate that we talk about why women are so few in terms of those who are recognized as having been wrongfully convicted. And yet in my work, I see far more women who have been wrongfully convicted, I would say, than I saw when I worked with young people and men. Not to say that there aren't, but it's a very different picture, and I'm going to talk about some key themes. I'm going to talk about those themes by talking about the women that I know whose cases we have tried to work on, some successfully, some not, and whose cases we continue to work on, and some of the ways that we try and see opportunities to prevent this, and also then to give you some unsolicited advice. Those of you who know me know that I'm good at that, giving all kinds of advice, and those of you who are future lawyers, watch out, because now that I know you're interested in this, I'll come looking for you as soon as you're ready to practice. So I'll talk about a few themes that I've seen, some of the women I've worked with and had the privilege of walking with, and what I would suggest a lawyer might do, and how we can change around what we made this title, which is Convicting Women, Easy to Do, Well Nigh Impossible to Undo. One of the main themes is, as Deborah and Emma have talked about in their work, that too often the focus of wrongful convictions is innocence, factual innocence. And when we're talking about, this was a shock to me when I started working with women. I had worked with women in the community, but when I came into this job, it was the first time that I combined working with women in prison more exclusively with the issues of wrongful conviction. And one of the things I found is that very few women do not take responsibility for something. Even when they may not be legally responsible, very often they take moral or personal or familial or community responsibility. And so the notion of factual innocence doesn't sit well when you're talking about trying to review the cases of women who are in prison. Because almost all of them, whether it's because they are resisting violence that's being perpetrated against them, either by fathers or partners, or so in situations of violence against women, often they will not characterize what they have done as something that they are deserving of exculpatory explanations. So they will take responsibility. Often, if they've used force to repel force, even if they're in the midst of being attacked themselves, they are often the ones to first call the police. You know some of those cases here, and I'll talk about a couple of cases that happened right here in this area. And they often then will first be the ones to provide the police, if they arrive, when they arrive, with the evidence that then gets used against them when they go to court. And I'll talk a bit more about that. So very few women claim factual innocence. And so many of the programs, even in the one that operates in the University of Ottawa, where I've been having the opportunity and privilege to work with law students for the previous 7 years to this, there they called it the Innocence Project. And in fact, a lot of the conviction review projects are called the Innocence Projects. And even as the Association in Defense of the Wrongfully Convicted initially required a factual innocence component. I understand they're in the midst of, I think that's changed now, but actually I could stand corrected. But I think they're in the midst of changing that. And it's extremely rare for women to claim factual innocence. They take responsibility. And a component or a facet that we've coined, and Native Women's Association of Canada and ourselves have used it particularly to describe the situation for Indigenous women. What we talk about is the moral hyper-responsibility for everybody else with whom they're involved. And so not only do they take responsibility, they internalize a kind of hyper-responsibility. And we reinforce that. And how do we reinforce it? Well, if you think of battered women who, if they do call the police, oftentimes they're first told it's a private matter, something they need to sort out. They may actually believe that as well because they've been socialized, and we reinforce that at every level in the system, to believe that it's their responsibility to solve it in the home. And so they're essentially given the message that they are responsible for that violence and to prevent it and to stop it. They're especially told that if they have children, and that violence may be perpetrated against their children. And then they're essentially deputized because they're told that, and so the responsibility is clearly, I need to defend. And so sometimes, the way it's, and too often the way it plays out, is then they accept that responsibility of being deputized to protect themselves and or their children or other family or other members of the community. And then they, when they act to do that, the same system that didn't protect them immediately swoops in to criminalize and likely imprison them. And so that's what I'm talking about when I talk about hyper-responsibilization. And there's a very good piece that was written by Mary Eberts and the late Trish Montour about this that if any of you are interested, I can certainly give you that site. And then the other thing that happens is even if they recognize that they should not be being held criminally responsible, which is not usually the situation, but even when you sit down and talk through that process and explain that in fact there's a difference between feeling morally responsible and accepting legal responsibility and pleading guilty, even if we get to that stage, if you happen to intervene before that stage, almost always, because of the misogyny of our system, we will expect other people to verify their version of events, particularly if it involves violence against women or children. And so who is the usual corroborator of that evidence? That there may have been a prior abuse, that she may have been fighting back. Often it's children, if it's a woman involved, or other family members. And oftentimes women will refuse to allow their children, if they have feel they have any control at all over it, will refuse to allow their children to be used as the witnesses in support of their defense, either because of stigma or trauma or a combination of both. So what does that actually look like? So let me give you an example of a case that unfolded here that in fact Deborah was also very helpful and involved with. This was a woman who I'll call Elle. And this woman I was first contacted because what I was being told was she had pled guilty, but there was some evidence of battering, and they wanted some Gladue factors in Section 718(2)E of the Criminal Code. And they understood through Native Women's Association that, in fact, I might be able to be helpful at the sentencing stage to maybe testify, to give some ideas. So that's how I became involved. So those of you who know me know I don't actually work on a case. I work with people, and I first wanted to meet the woman. So I came to Winnipeg because of some other meetings and met with her. And when I met with her, it just happened that the lawyers, and there were very good criminal lawyers involved. So everything I'm going to say, bear in mind, this was not a case where I'm saying anything about incompetence or anything in terms of counsel. There were very good lawyers involved. They had gone through all the steps. But I wanted to meet with her, and serendipitously, as it turned out, the lawyers all had to go to court for some motion. So I sat down with the woman, and the long and the short of it, and the story was that she had confessed to the police. As soon as she called the police, she confessed to the police, and then they just proceeded from there. So I hadn't read anything before, and that'll be one of the tips I'll give you later on, is I encourage you first to meet the person you're going to be representing, not to read anything about them. Sometimes you can't avoid it because it may have been in the paper or whatever, but first to get your first information from the client. So I went and met with Elle. In fact, we had tea, and it took a while, and we were talking about general things, and then eventually it got around to, and I said, so they say that you say you did it. And she said, yeah. And I said, well, so that's what happened? You actually stabbed so-and-so? And for the first time, her eyes came up. She's an Indigenous woman raised mostly in her community for most of her life, and then married into another community. And that was the first time she looked up at me. She says, no, I didn't do it. And I said, well, they say you did it. And so then I went about, I'm giving you the Coles Notes version, because otherwise we'd be here for an hour describing how many times I tried to think of ways. And what I tried to do is think of every single way that someone might have interpreted what she said as her saying, I did it. So I went through and all kinds of scenarios, like sometimes people are partly involved, or they're involved after, or they help do something with the body or with the evidence. Went through. And it was when I got to, and sometimes people feel responsible, and so that gets interpreted as guilt. And she said, I am responsible. That's when her eyes came up, and she looked at me and she said, I am responsible. So I thought, okay. So I asked her then, and eventually we got out, why did she feel responsible? Because the man who had been stabbed was her nephew. She had raised him as her own son. She knew he had an alcohol problem. The night that he came over and was stabbed, she gave him his first beer. She knew that her ex-partner was coming over, who got very violent, who he had put her in hospital, and in very grave circumstances several times, and knew that there might be violence. And she knew that his ex-partner was going to tell him that night that he was not the father of the little girl that he adored. So she felt responsible because she raised him as a son, she gave him alcohol, she knew that there might be a fight, and because he was going to hear some information that he might not be happy about. So she took responsibility as a woman from that community, in a mother role for this young man, and as someone who could not protect herself from the man who I still believe, and most people who end up involved in the case believe, actually killed the young man. But he was also related to leadership in the community they lived in, related to the police in that community. The house where they had been had burned down shortly after this incident. Evidence had disappeared. And she knew all of those things that I didn't know at that stage. She knew that she ultimately would have to take responsibility for this because nobody else would. And if she didn't, the implications for her, her children, her grandchildren, others in the community would be so many and so complex and so long-standing that the only other option would have been for those charges to be dropped against her. So we went through a process of exploring all of this, going back, revisiting, looking for the evidence, checking out. That's how we found out the house had been burned down. Checking all the individuals. The man who I still believe was responsible for the death came to the place she was living and threatened her. We could not even get a restraining order against him because the threat was not seen as overt. It had been 6 weeks before we went to court. We managed to get the judge convinced that we should reconsider the guilty plea. But in the process, when it became clear that the Crown, I would say the Crown knew, I don't know what was in the Crown's head, but it was pretty clear the Crown knew that this woman was vulnerable And when it became clear that the charges were not going to be dropped, she insisted on pleading guilty again and was sentenced. And it was not for murder, which was what she was initially going to be tried for, but for manslaughter. And in the relative scheme of things, it looks like a short sentence, which I'll get back to. So it looks like a short sentence for manslaughter. But for me, and for anybody who was close to it, everybody knows that it is fundamentally a wrongful conviction. And it is a case, actually, of factual innocence. But the key person who we rely on to claim factual innocence will never, ever see it as that. She still maintains that she had a moral responsibility and a moral obligation to protect that young man and to protect others in the community, including her family. And so that case continues on the books as a manslaughter conviction with no description of any of what I've just told you. And with her absolute unwillingness to have any of it publicized, hence the reason I'm using an initial. Because the risk continues for her that she and her children and her grandchildren may be at risk if she ever does speak out publicly about what actually happened. So that's L. Then a visit, shortly after that visit in this city, I was invited by some of our court workers to go and see this really progressive sentencing that was going to happen. Everybody was excited. It was going to be, it was a sentencing for manslaughter. This is before the mandatory minimum that wouldn't allow this anymore, parenthetically, so another good challenge for all of you new, young, budding lawyers to take on. So now there's a mandatory minimum, but there was a young woman who had been, who again had pled guilty to manslaughter and was going to receive a conditional sentence. So it was seen as a really positive thing. Elders were involved, her community was involved, and our court workers were involved, some Native court workers. So I was being invited to come because it was a great example of everybody working together and doing a very progressive sentencing. I was horrified after I'd been sitting in the courtroom for no more than 5 minutes as I heard the facts read out. This is a young woman who had been raped many times. She'd been drinking at a party, been raped many times. And when she came to after passing out from a combination of probably the alcohol and the incredible abuse that she'd experienced through the rape, the physical and sexual violence she'd endured during that gang rape. When she came to and the man who died started to come towards her with his pants open to rape, presumably to rape her again, and she reached for a broken bottle and jabbed him with it, he died. And everybody agreed that she was responsible. So now it wasn't just this woman taking responsibility. Everybody agreed. I talked to her lawyer, and he said, if you could have done anything to convince all of these people, then, you know, I would have called you. But nobody was willing. So here we had what was characterized as a restorative justice approach, progressive, great idea to see people coming together in the community. The community was all supporting it. But it was also very clear that this was a case where self-defense was. I would again argue that police should never have laid the charge, given what had occurred. But even when the police did, the Crown should have then withdrawn it because it was clearly a case of self-defense. Even the judge was essentially saying that as he was basically agreeing to a joint submission on sentencing. And the people I was with didn't understand, and the elder kept telling me, "You don't understand. She has to take responsibility. It's wrong to take a life." And that led to a whole series of discussions with people like Deborah and the late Trish Montour and others, and led to actually that article that Native Women's Association and ourselves had Mary Everts and Trish Montour co-author about the hyper-responsibilization of women. Because here was a situation where legal guilt was being equated with moral responsibility in terms of the taking of a life. And so it started a series of discussions about how do you bridge some of those that are, cultural divide seems like too weak a description, but how do you bridge some of those incredible gaps between people's sense of community and responsibility and morality when, in fact, we're talking about a legal system that doesn't operate that way, that is a legal system, not a justice system, but a legal system that does not recognize the differences between moral culpability and legal responsibility. Then there are several other women that I'll talk about. I'm just looking at time now. I want to leave time for discussion. But then I think of people like Jamie Gladue. What are the facts in Gladue? Anybody remember? Well, you brilliant law students will remember. What are the facts in Gladue as they're accepted by the Supreme Court of Canada? Yes? That's right. So the Supreme Court of Canada recognized that here is a situation, and the facts as they understood them, as they were put to them, was this was a woman who found out that her boyfriend was sleeping with her sister, and she was drunk and she stabbed him. Everybody remember that case? That's how it's... Anybody here read the preliminary inquiry? Yes, yeah. So Deborah has. So, do you want to summarize what the facts are? Yeah. So, what actually happened, this is a perfect example of how imperfect our system is. So, when we were going to be using, without going into details, I go into prison, so you can probably imagine I've met lots of people who have been in prison, and so I'll just leave it at that. But it made me want to look more at, as this was being appealed. So initially it was appealed, well, one of the issues that happens is when you do have counsel who don't get it, very few other lawyers are willing to say, that lawyer did a bad job. Whether, that's true of any, it's true of families, it's true of professions, it's true of most areas, that nobody wants to say they did a bad job. But this was one of the most egregious examples of racism and racist misogyny that one of the many, I guess. I'll just leave it at that. It was clear that the police, the Crown, the woman's own lawyer, and the judge didn't quite get what was really going on. You just have to read the preliminary inquiry transcripts to see the bias when all the Indigenous individuals who are the witnesses are being asked what kind of beer they drink. None of the other witnesses were asked what kind of beer they drink. When you see what is clearly a break and entry and a rape described as an affair. So the facts are that Reuben Beaver had crawled into the window, through the window, broken into the bedroom of Jamie Gladue's younger sister and raped her. Then gone back to their house to beat up his 19-year-old, pregnant with his second child, girlfriend. When he went back to try and get back into the house where her sister was, she chased him and tried to stop him. She did stab him. But again, at the very least, many of us would argue that is defense of other, if not her own self-defense as well, because she had been beaten up. And she had been hospitalized several times because she'd been beaten up before by him. And her father had moved, as a single father, moved his entire family from Alberta to British Columbia to be there because he was afraid that Reuben Beaver might hurt Jamie. And he refused to ever allow any of his children, his other children, to be left alone with Reuben Beaver because he was fearful of what might happen to his children. So why isn't that what gets appealed? What gets appealed? On what point was Gladue appealed? Why do you even know it, know the case? Well, the other thing the judge said is that someone tried to raise Section 718(2)(e), which, by the way, doesn't just apply to Indigenous people in sentencing, but in particular, you're supposed to look at the impact of many factors on Indigenous people who are convicted. But that sentencing principle says that you're supposed to look at all of those factors. And the judge, when he was asked to consider Section 718(2)(e), apparently said, I can't remember the exact, and those of you who have read it recently will correct me, but said something like, well, she doesn't live on reserve, and it only applies to Indigenous people or Aboriginal people on reserve or Natives on reserve. I can't remember the exact language he used. So that was the point that was appealed. Why? Because who wants to take on the entire system as being racist and misogynist? Who wants to take on that this is actually a wrongful conviction? So instead, Gladue too often gets used by less progressive lights in our legal world and not so legal, and other worlds, journalistically and others, as somehow, I've heard it described as a get out of jail free card for Indigenous peoples. I've heard it described as all kinds of things, as a double system or reverse racism, which is absolute nonsense. What I hope all of you remember that Gladue is really about is how a system protects itself when it really screws up. Because Jamie Gladue, I would suggest to you, is another case of wrongful conviction. It should have been recognized as a wrongful conviction. She should have been protected. She wasn't protected, not just on that night, but many other times when she was attacked. And for it to stand for a sentencing principle alone, I think is a bit of a travesty. So whenever you read about the Gladue factors, think about what we're really talking about is trying to correct after the fact a whole bunch of mistakes that we're not even willing to really expose as being what the mistakes were in the first place. So post facto, we say it's about taking into account the horrible things that have happened to Indigenous peoples. Not to trivialize, but residential schools, 60s scoop, poor living conditions, what the UN has said about the situation of Indigenous peoples in Canada. All of that is to take into account to alleviate or to mitigate sentencing. But what we really should be looking at is why did they have to dig around and find that kind of technical point? Another case that you may have that went to the Supreme Court of Canada is Ryan. Ryan was the case where a woman had gone to the police or police-based victim services. On the record, the trial judge accepted at least 11 times to get support and to get assistance. And she was basically not provided with that support and assistance. And her ex-husband was still coming to her home, to her workplace, threatening her. And when she asked for assistance, she was told it was a civil matter. The police couldn't do anything about it. And yet, when her father then said, well, we'll just have to take, or I don't know exactly what he said, but essentially we'll take matters into our own hands, and suggested that they hire someone to kill him, then the very same police detachment, well, you're not supposed to know that because it was kept quiet, but it's small town, rural Nova Scotia. It has to be the same RCMP detachment, then sets up essentially a sting operation and has a police officer pose as a hitman to then get money out of Nicole. And the minute she does that, she is charged with conspiracy to commit murder. So we see the retreat of the state in terms of support services, protective services, the intrusion of the state, intervention of the state to criminalize and try to imprison. So even though the judge at trial recognized that she was essentially living under a reign of terror and challenged the police actually using the law, not using the law to protect her, but then using the law to criminalize, attempt to criminalize and potentially imprison her, the judge accepted a very creative argument made by her counsel, which was that she was under duress. So the Crown decides to appeal it. The Nova Scotia Court of Appeal unanimously will not allow the appeal. Goes to the Supreme Court of Canada. The Supreme Court of Canada allows the appeal because they recognize it's an important point here. Self-defense wasn't available. Why? Why couldn't she use self-defense? Those of you who are law students. Guess? This guy had threatened her life. There was no issue. Yeah? Yeah, there wasn't an assault in progress. So nothing actually happened to her ex, right? So they intervened and arrested her as she was trying to hire someone to harm her ex, but nothing actually happened to him. He wasn't assaulted, he wasn't killed, and nothing happened to him, so self-defense wasn't available. So he argued duress. I would say there may be an argument for necessity as well, but he argued duress. And the Supreme Court of Canada recognized that there was a real issue here, recognized that this was, they were about to be invited to abandon all opportunities for women in those situations to have the protection of the law in a situation where it just screamed injustice. And so instead of, though, tackling the very real case of how do we construct offenses in a way that will actually work for individuals, and particularly women in these situations, they instead sidestepped it and just said, we're going to say there'll be a stay of proceedings. We'll overturn this acquittal. What's supposed to happen when you overturn an acquittal? If they overturn the decision, she should have been sent back for trial. And they recognized the fundamental injustice of doing that, given that she'd never had the protection of the law, and so they ordered a stay of proceedings. So I think they kind of wimped out. Not that I'm saying to any individual judges who may see a tape recording of this that you're individual wimps, and I'm not calling any Supreme Court of Canada judges names, but I think it was a prime opportunity for them to say, no longer should we draw bright lines between defenses and let people fall through. No longer should we accept that women and children who experience violence should be treated in a different way. We should demand that there be some fairness and justice. And so what does that teach us? And actually, I'll just talk about one final case, a woman who finally is allowing us to, I hope she will still allow us to continue. Almost 20 years ago, more than 20 years ago, 20 years ago, as of April 22nd, this year, 2014, she has been serving 20 years in a life sentence for a crime that most everybody else believes she never committed. This woman was in the prison for women already. Some of you will recognize the date. April 22nd is the day that other women got placed in segregation, stripped and shackled by a male emergency response team, and led to the Arbor inquiry. But this woman was already in segregation because that day she had pled guilty to second-degree murder. Now, parenthetically, the lawyer who helped plead her guilty was subsequently disbarred for sexual abuse of clients. He now has a brain injury, which is very sad, but he can't testify about what actually happened or what he was thinking at the time. Every woman who served time with this woman says there is absolutely no way she committed any crime. They don't even believe she assisted the woman. Some people who work in corrections say it may have been an assisted suicide. On the books at the Prison for Women and through the Correctional Service of Canada, the woman who died is still classified by some as undetermined death and others as a suicide. Most everybody agrees, who even thinks she was involved, that she may have helped tie the noose for the woman. But even her description of where the noose was, how it was tied, does not match the pictures of how this woman was hanging. This was a woman who had been talking about wanting to commit suicide for some time, and when she did, this woman tried to take responsibility. And ultimately, it was when she called in the media and pled guilty, literally on the front page of the Whig Standard, the paper in Kingston, Ontario, that the police felt they had no choice but to lay charges, and then she pled guilty. She tried to plead guilty to first-degree murder. And she now finally will write. She felt bad. She felt that she should have done something else to prevent this woman's death. So again, moral responsibility. She was afraid to get out as well. She is a residential school survivor, 10 years in residential school, out for 6 months. She's the same age as me, and the same age as I was heading off to university, she was being sentenced to prison for women for a very minor crime that then escalated, and some of you will know the story of Ashley Smith and how sentences can be accumulated inside. And when she was getting close to her parole eligibility date, she pled guilty to this and has not been out. So her entire adult life, she has been in prison. And she has finally agreed that we can try and do a conviction review of her case. where we will be arguing factual innocence, I hope, and where it has taken almost 20 years of back and forth with this woman and talking to her and getting to know her and some trust for her to be willing to acknowledge that maybe she wasn't legally responsible for this. So what are the lessons, and what's the lawyer to do in these sorts of things? Well, as I've said before, I think as a very basic, one, first get to know the person you're going to be representing. You may have heard something in the media, you may have be given some things to read, but first, please meet with the person you're going to represent. And if it's a woman and you have no lived experience of violence or racism, try to inform yourself about some of those issues before you go and meet with her. And be fact conscious. I had someone say that to me when I was in law school, and I had no idea what they meant. It was a very senior lawyer and law professor, and he said to me, "You'll never go wrong if you're fact conscious." I had no idea what he meant. He later told me that, I was doing an okay job, but I could really improve on that. And so I've since, and I now realize what he meant was exactly that. Get to know the individual and check out all of those facts. We went back to the reserve where the first woman I talked about, where things had happened. I went to the prison for women and checked the bars and the description of, and sometimes you see things that you wouldn't otherwise see if you just read the report and the interpretation put on those facts by whoever is taking them down. If it's a police officer, that is, of course, the Crown's case at its highest. And you may need to check and challenge that. And so many times we've been able to challenge eyewitness accounts because you realize that the person who's saying they saw what they saw may have heard something but couldn't conceivably have seen. And if you can show that by reconstructing the room or the place, that can help. Getting experts or others to assist. Now, sometimes those experts, I put experts in quotation marks because sometimes those experts aren't people like psychologists and psychiatrists, but somebody from the community who can help interpret. People like Trish Montour and women and elders from communities, when I don't understand the dynamic. I didn't understand the dynamic of why this woman, Elle, would take such huge responsibility till I started to meet people in the community and realize that, of course, if the chief and the band counselors and the police were all related to the person who may have been responsible, there is no way we're ever going to get, no matter who is factually innocent, if, in fact, that person ever wants to go back to that community. So having experts to assist and also to help interpret that to whether it's the Crown or the judge in terms of who you're interacting with. And make the Crown do their job. As an officer of the court and as a representative for the Crown, they need to make the case out. Make them make the case out. Challenge the evidence. Know those facts, know that information, and challenge it. Challenge the stereotypes of gender, race, etc. that are available, or that are at play. Get support for the woman. Being cognizant of the issue of records, the support may come in different forms. And what I'm talking about is, of course, the ability of records to be subpoenaed if you're getting a counselor or that sort of thing. But really, women and I would say most anybody going through the system needs support. But ensuring that you have people to provide that support. And have advocates and champions for those individuals so that you can partner with them. Many have said that some of the work we're doing now, which sometimes makes real lawyers, I call myself not a real lawyer, and I'm not a real lawyer. One of the women once called me a recovering lawyer, and I like that sort of idea. I'm not really, you sort of have to be one to recover, but whatever. So, but to really, some of the lawyers get uncomfortable, for instance, when we go out in the media in advance of cases. But in my experience, sometimes when we go out in advance, like in Ryan, I'm not sure the Supreme Court of Canada would have made the same decision had we not been making such a fuss about the inability of women to defend themselves when they're being battered and the lack of appropriate responses in the system. So certainly link up and partner with champions and advocates who are able to take those positions and are able to speak out. And that's even if you're not uncomfortable, sometimes your position as an officer of the court and as someone given in, I'm sure you have an ethics course here. Maybe ask your ethics person whether you could do media about it. But I think you can do that. And in the importance also of educating others. And the process of educating others, as I mentioned through the last woman's case I was talking about, as painful as it has been for 20 years, it's been vitally important that we take the time to ensure she knows why she is in control of this process, but also why it's so important, not just for her, but for many others, that she challenge what happened to her and her taking responsibility in the way that she did for a murder for a death that was not a murder and for which she should never have been convicted of murder. That her desire to have support and her lack of available supports in the community should never be used as an excuse for people to allow her to plead guilty and to continue to challenge that. So I encourage all of you, and if I think we have a few minutes for questions, and certainly I encourage all of you to challenge that. And one of the ways that I start out, usually I didn't do it today because it didn't really apply, but if there's no questions, I will use an example of what I do with first-year law students. So, just in case. So I want to thank you, and on this inaugural day, I think to be very vigilant as you go out in the community and do, whether it's as law students or as future lawyers, or as individuals, as community members, to be vigilant of these kinds of injustices and to do everything you can to name them and refuse to perpetuate or perpetrate them. And if you do that, then you'll live up to the quote that I often use of an Indigenous woman who I had the privilege of meeting a few years ago, but I was first given this quote by a woman who was serving a life sentence who we were just, I was just emailing back and forth before we came to the class. Her name is Gail Horry. She's an incredible advocate, taught me most of what I know about what happens in prisons. And the quote is from a woman named Lilla Watson, who's an Indigenous woman from the area that you know as Brisbane in Australia. And it goes like this: if you've come here to help me, you're wasting our time. If you've come here because your liberation is bound up with mine, then let us work together. So I look forward to working with all of you in the future.
Thank you, Kim, for that and for leaving time for questions. So I want to open it up now for a question. We'll go in the back. Let me get you on the mic here because we are on the video.
All right. Thank you. Please, I really want to know if you have a written article in respect of this topic you just pretend now, and if you have written article to that effect, how can I assess it?
I haven't, because the best writer on this is your professor right there, Deborah Parks. And is this out yet?
It's under review at a journal now.
Sorry. Okay, well, I'm sure it will be out soon.
So with a colleague at UBC, Emma Cunliffe, we have written an article on women in wrongful conviction. Why I didn't want to be the one talking today is because I actually think it's more important and more useful to hear from Kim, who's actually, so much of what is in that article, we draw on all kinds of other research, but the germ of the ideas in terms of taking a very critical eye to what we think of as innocence, what we think of as wrongful convictions, through the lens of women, through race and gender, came from Kim. And so, and that's why it's important to hear from her. So anyway, we have a piece. I can send, people, if you're interested, send me an email and I'll send you a copy of the draft. Em and I are both interested in feedback on that. We're waiting to hear from the journal. It's an international journal, whether it's going to be published there or elsewhere.
It better be. I'll find out who the journal is.
In addition to that, so it's under peer review right now.
Whoever you are, you're stupid if you don't
in addition to that, though, Kim has written, she's very modest, she has written a number of pieces that, on various aspects of the work that she's done. She and I have co-written other pieces, not so much on this topic, but on the issues of advocacy with respect to women in prison and some of the challenges of trying to advocate, with a critical eye on how often, as I mentioned before, that when you're trying to reform and you're trying to bring, address the very real human rights issues that exist in women's prisons, which is where our focus of our work happens, but also in the men's and the youth jails, is that so often those efforts can then end up in an increased carceral net, increased different kinds of interventions now in terms of new prisons that get built. So when the women's prison, we talked about it earlier, when the women's prison got closed, prison for women got closed, we now have way more women in federal corrections. I don't know, how many more? Three times as many,
more than three times,
yeah. Than we did when the prison for women was closed, because there's sort of, we're expanding our prisons generally, and you guys know about this through increased sentences and the like. But so that's the kind of work that we've written up as well. But Kim has done a lot of her own work. I mean, you'll see the lapel pin. She just recently received the Order of Canada, both for her advocacy and her writing and many of the other things that she's been doing. So. But I think we had some other questions. Yeah,
so
Casey?
The article that Deborah and Emma wrote, though, is called Women and Wrongful Convictions, Concepts and Challenges. So it hopefully will be out soon, but yes, get it from.
Hi, I just want to thank you for your really useful comments to us as potentially future very diligent counsel on these matters. But I had a question regarding, before you get to the point of laying charges, if you could speak maybe a little, if you have any ideas on what could be done at the evidence gathering and investigatory stage to sort of, because it seems as though you're articulating very three-dimensional contextual factors that are getting shoved into this one-dimensional sort of legal framework. Mm-hmm. And what can be done maybe from police to sort of mitigate that friction?
Yeah, well, we've tried to encourage, a very good question, thank you. And yes, ideally preventing it before we get the Crown's case at its highest, which is the police reports. And really to sensitize police to those realities. They're not always as receptive to the training as we'd like them to be on this issue. And many times they are seeing it or hearing it through the lens of their own experiences, and as are the women they're going in to investigate. So let me give you an example. Even in situations where we have police who I think have been fairly sensitive to this, in fact, the best intervention I've seen was not a surprise in some respects, an Indigenous woman police officer who I was actually out exercising, and this woman was running down the street screaming. And so we went to intervene. We got there at the same time as the police got there, and this one particular police officer was there. This was in Ottawa, where it was 2 years ago, I think, 3 years ago. And when the officer arrived, the man was still there, and the police were arresting him. And she was saying, no, I don't want him arrested. I don't want him arrested. And so they were saying, well, no. And this police officer said, look, it's not your responsibility. We have to take responsibility to take him out of here and make sure you're not harmed. And she said, so I don't have to do anything? And it was clear she was fearful of what would happen, and so that was another piece that I didn't say, that many of the women will feel responsible also because they think they've internalized the notion that somehow they're responsible for the abuse, that they can prevent it, they can protect, so that's a whole other issue. But and this police officer is the first police officer I've ever heard clearly articulate. She said, it shouldn't be this way. It's not this way for any other crime. And that's the example I was going to use, that I use with first-year law students. It shouldn't be this way, but yes, unfortunately, probably you will have to make a statement, and you will have to testify if he goes to court. And she just broke down, and I said, well, and she said, but we should get you some supports so that's progress. And I think we should expect police officers to be honest. We should also then be challenging, and I'm doing I was here last week for judicial education. I'm doing some in the next couple of months as well, some more, and reminding judges of their responsibility too, because misogynist violence is the only place where we hold that standard. So can I use the example I used of the first year? It's not really, it's sort of, it is relevant to this. So I always say, if we treated any other crime the way we treat misogynist violence, when my house was broken into and my TV was stolen, this is how it would have unfolded. The police would have arrived and they would have taken statements, and they would have wanted verification that I in fact had a TV. And maybe, and they would have gone through all that, may have wanted to check with my neighbors, they may have checked whether I actually put out, you know, a box on recycle day. And eventually, though, I would have had to take the stand. Now, I never did have to when my TV was stolen. There was never question that I was lying or that my TV had been stolen. I put in an insurance claim, and I got that. But if I had been treated like a woman who'd experienced sexual misogynist violence, this is how it would have unfolded. I would have been put on the stand for sure if there was anybody charged. And the questioning might have gone something like this. So isn't it true, Kim Pate, that you often invite people into your house to watch TV? And you kind of flaunt that you had a new TV. You put it out in a box on recycling day. You left the curtains open so everybody could see you had a new TV. You let people come and go and watch your TV. In fact, you know, you actually have lots of people come, and even people with criminal records sometimes you'd have in to watch TV. Weren't you essentially inviting someone to just take your TV? And you know, it's a bit ludicrous, but that is essentially how women are treated. There's an immediate questioning of whether, in fact, or you know, it might have added, did anybody else see that you ever lock your door? You apparently leave your door unlocked too. Aren't you really inviting people to come and take things? And you know, we don't in property cases have that same. We don't in lots of other violent cases. But in cases involving women's claims of having been sexually violated, we almost always, or being battered, we almost always require some other corroboration, because surely the woman must be lying. And I would suggest to you, even when I worked with young men who had been violated, I think because of homophobic, as well as other attitudes, there often isn't the same questioning of young men who claim to have experienced sexual violence. Because who would actually come forward and say they had been raped by a man or a woman if it weren't true? And so the discriminatory stereotypes and attitudes and myths of the system get reinforced at every stage. And so particularly for women who are, you know, again, many of the women we're talking about are criminalized as they're responding to violence, either defensively or reactively. And so they get treated in incredibly discriminatory ways right from the get-go. So.
Okay.
Did that answer your question? Sorry. No. Yeah, fair. Gave more than you wanted. So.
I'm curious about how you deal with the standard of review, because once you get past the facts being found by a trial court, you're kind of stuck with them. The tests are tough, and they do not admit of any kind of amendment at all, really, beyond palpable and overriding error, or in some cases, the sum evidence test, which actually requires the judge to be making stuff up.
Yes.
So you, like, I just don't know how you get past that once you've got the facts found by the trial judge.
I agree. And in fact, you know, in cases of misogynist violence, it's often that evidence was available. Like in Jamie Gladue's case, all that evidence was available. The fact that it wasn't utilized to defend her is the problem. And I mean, for Jamie, it would not have been an easy thing or a welcome. You know, I don't want to speak for her, but it probably wouldn't have been welcomed. And in most cases, it wouldn't be, because it would involve such exposure, re-exposure of the individual and her entire family, and particularly children, to what had happened. And so I agree, that is, and in the case that we're trying to bring forward now, one of the issues we have to do is we have to go through the step of trying to get appeals 20 years later, and we're probably going to be shot down, and then argue from a very strong perspective of, you know, factual error on the legal, you know, the incompetence of the lawyer to actually have even put forth a guilty plea in this context. But it's very difficult, I agree. And that's been one of the challenges as well, for sure. So thank you for raising that. I didn't mean to skirt over that. That is a very real. That's why you should read Deborah's and Emma's thing, because it's way better on all that legal stuff.
Very interesting and thoughtful presentation. I was just wondering, do you think, not only in cases that you described, you said many of the women pleaded guilty at trial. Do you think, as a general rule, trial judges should be more skeptical of guilty pleas, and if there's anything in the record that could raise a possibility even that the person is not really guilty, that the judges should question the accused at some length to make sure that there isn't a defense that he or she is overlooking.
Yeah. I'm sorry for starting to, I got so excited about your question, I started to interrupt you, so I apologize for that. Yes, I do. And when I mean, judges sometimes aren't very happy when I say this because there's, are judges supposed to be that interventionist or activists? And but I do think, one of the things I tell all the judges is after, I forget what, it wasn't any of the cases I've talked about, but another case where there had been an agreed statement of facts put in, and we managed to have it was another one where a guilty plea, actually I should have told that story because that's a happy ending. We actually got the guilty plea what's the word, I've got mental pause, what's the word I'm looking for, Deborah? Withdrawn, yeah, but there's a process for the legal process. No. Anyway, you'll come up with the word. Yeah, anyway, there's a vacated, that's it. Hey, A, who is that? She gets an A. No, sorry, I don't have any power to do that. So had the guilty plea vacated, and we actually showed that, in fact, the woman didn't even understand what she was agreeing to. She was so drugged up. She was so distraught because the love of her life, even though he'd been incredibly violent, had died, and she took responsibility. Anyway, in the end, everything was stayed. It was a case where we actually, and there are a few of them, I should have said that, there are a few where we've managed to intervene at that early stage. Oftentimes, what we'll do is our workers who go into the prisons, if they hear someone's been arrested, and it's been a situation of violence, usually other women will tell if the woman doesn't tell herself, then we'll try and intervene with the lawyers right away. And in some cases, we've been successful, not all. But in this case, it led to, there was an agreed statement of facts that she had agreed to. And it made me realize, like, she was so distraught, she didn't even know what she was agreeing to. And so I started going to every prison, and I visit the federal prisons, a lot of the provincial jails as well. But every prison for the next year, I asked we'd have assemblies about, because I do talks about human rights and stuff. And every prison I asked in the assemblies, okay, I know, how many of you have pled guilty to something? I don't want you to tell me what it is or have I disclose anything. Every single woman would have pled guilty to something at some point in these assemblies, with maybe a couple of exceptions. And I said, okay, who can tell me what an agreed statement of facts is? And it might be called something else, but it's where your lawyer and the Crown, the prosecutor, come up with what happened and tell and something, but it's basically an agreed statement of facts. Not one woman in any of the prisons I went into that year thought she had done an agreed statement of facts. And what does that tell you as a future lawyer? It means that, one, they may have been traumatized. I'm not saying lawyers didn't do it. I'm not saying lawyers didn't go through the agreed statement of facts with the women. Some may not have. But what it told me is that they weren't in either a state of, because of, some of them would say, well, I was so drugged up because I was taking tranquilizers just to get through the process. Or, well, I was, that was my lawyer. I had to do whatever they said. Or they said if I didn't accept that version of what happened, that we'd have to go to trial, and I didn't want to do that. So they might, as we sort of peeled the layers back, there were all kinds of explanations that maybe they actually did have some idea that something had been put forth, but they actually did not own it. They did not understand it to be their agreement that that's what happened. And the significance of that I was trying to explain to the judges is whatever they agree to, you sentence them on that basis. And then if they go to prison, they have to do programs to solve whatever issues are seen within that statement. So if she's not agreeing that she actually was drunk that night, let's say we use an example, she's not going to think, and has no alcohol problem, she's not going to think she has to do drug or alcohol treatment in prison. But unless she jumps through that hoop, she's never going to get recommended for parole or get out in time. And so it impacts everything along the way from then on. And so we do talk to judges about the need to really ensure that if there's an agreed statement of fact going in, that in fact the individual understands what all they're agreeing to. Not just for women.
If I could just sort of build on that just a little bit. One of the things is that in law school, and some of you are already doing legal aid work and you've had some experience in the courts and you've seen a little bit of how things work in different ways. We have quite an idealized version often of how things actually work in terms of, sentencing, bail, guilty pleas, whatever. The reality, and I see some folks here who are doing the work and who I know, and the reality is, it's quite different. Things happen very quickly. And you will have very high caseloads. You will be dealing with all kinds of matters. And if you aren't willing and ready to challenge on some of these things, and that means within legal aid, that means within your firms, that means within the Crown Office, and it's very tough to do that unless we have people speaking out sometimes about the pressure that they're under to bring cases, to process cases, we're not going to have much change. And I don't think it's all on your shoulders, but I just think, and those of us who are working at a policy level, we bear some responsibility in talking about this. But the other problem is we don't actually have good research often on some of these things. And that's where I see my role and some of the role that law students can play working on different research projects. I just had a graduate student last year do for the first time a study in Manitoba, a 2-week study of sentencing disposition hearings and how many of them are joint submissions and how much time actually goes into, so I did a court observation into considering them, and it's very quick. There's the upwards of 65% of the cases that he observed were joint submissions in which they're just, and that's not only agreed statement of facts, that's beyond, you're not even making submissions as defense as to what the sentence should be because you're agreeing to something. And I'm not saying that's not appropriate in some cases, but I'm a little concerned, and we had some suspicions about this, and we need more research about how much a culture of expediency in the system really has an impact on both the sentences that you might get, as well as wrongful convictions quite clearly and quite literally. That I know within those, there are wrongful convictions happening every day in Manitoba. I believe that, and that is because we have a system that is churning people through in ways that is really not at all in accordance with what we expect it to be. And I'm being a little bit soapboxy right now, but I do think that we all bear a responsibility in looking very hard at that and what's happening, every day. And I know that many of you do really good work, and so do so many of the lawyers and judges out there. And it's not about individual people, but it's about a system that is, in many ways, very much on its own momentum. And it's very hard to kind of to make those changes. But I'm urging you to take up Kim's challenge and to do your work and to think about your own role and conscience in all of this too.
Hear, hear. See, now you know why you got to read that article.
Well, I mean, I bet there are more questions, but Kim may be able to stay for a few minutes, but I think we should wrap up the sort of formal part of our day today, and I'm just having to go over here and get just a small gift that we have for Kim on behalf of the Faculty of Law. I want to thank you for making the trip here to Winnipeg, just a coveted Robson Hall coffee mug.
Thank you.
Thank you so much for the work that you do.
It'll be on display in the College of Law at Saskatchewan.
And I actually also want to say, one other thing. I have brochures here for AIDWC, Association in Defense of the Wrongfully Convicted. As you know, this event is, we're sort of co-presenting with AIDWC, and they wanted me to make sure that folks could grab brochures and become members of AIDWC if you're interested. And I see Nikki and some students here who've been interested in maybe having a chapter of AIDWC or being involved in some work here. There may be some work that students can do on cases, and pick up a brochure if you're interested. Talk to me or Nikki. Can they talk to you too? Yeah, probably Nikki's the best person, and then we can connect about whether or not it makes sense to start a group or whether folks want to be involved in AIDWC work in other ways.
Great. And today, for Wrongful Conviction Day, one of the things you can do is there's a press release just put out by AIDWC today about Romeo Filion, who was wrongfully convicted, and the government is refusing to follow through on their compensation of him. So just send a quick email.
is quite elderly now,
Yeah,
and you know, there's a concern that they are waiting him out.
Yeah.
Quite frankly,
That's
it's quite
right.
reprehensible.
So
Actually,
send a note just saying not in our name. Yeah. Great.
okay.
Great. Thank you.